Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, a podcast produced by the Antitrust Law section of the American Bar Association. I'm Anant, Raut, host of our sister podcast, Trust and Trade. And today we're diving into the question, what really changes in antitrust enforcement when a new president takes office? So let me start by introducing my co-host today, Anna Olson. Anna is a 3L at Drake University School of Law and a law student representative on the section's podcasting committee. Hi, Anna.
Hi, Anant.
Now, Anna, this idea came to you while a member of the White House Historical Association Leadership Group. Tell us about that.
Yes, so the White House Historical Association has a next generation leadership group that is full of professionals from different backgrounds that work to amplify the Historical Association's mission. So essentially posting on social media and talking about the White House and the presidents that lived in it. So that's really where I got the idea for this podcast, because I thought, what is the antitrust connection to these presidencies who work to promote the antitrust mission and maybe who let it slide?
So why don't you introduce today's guest?
Yes, our guest today is Michael Kades. Michael is currently a partner at the Nachawati Law Group, where he leads the firm's antitrust government entity practice. Michael is a former Deputy Assistant Attorney General for the Department of Justice's Antitrust Division. Prior to coming to the U.S. Department of Justice, Michael was Director for Markets and Competition Policy at the Washington Center for Equitable Growth. He was also antitrust counsel for Senator Amy Klobuchar, chairwoman of the Senate Antitrust Subcommittee. Prior to that, he spent 18 years in various roles at the Federal Trade Commission. Hi, Michael.
Hi, Anna and Anant, and thank you. And it's a pleasure to be back on the podcast.
Yeah, nice to see you again, Michael.
Yes, so antitrust enforcement isn't a self-operating system. It's a policy space that reflects presidential priorities or the absence of them. In today's conversation, we explore what drives enforcement, the impact of political will, the role of institutional precedent, and how procedural shifts can either amplify or erode its political relevance. So before we dive into questions here, Michael, can you lay out your general thesis, kind of your ideas of how antitrust has changed throughout the world so far?
As I look over the whole history of antitrust law, I'd say, it's politics interacts with antitrust in three ways. One is politics where antitrust becomes politically salient. That is when you tend to get big changes in antitrust law. The second way, which has frankly been most of our history since the passage of the Sherman Act, is where politics it's just neutral. Like it isn't important to Congress at the moment or the White House. In that situation, it's kind of like antitrust just kind of goes on the path it's on. And you will get, from an antitrust doctrinal perspective, you get significant changes, but the ground doesn't shift. And the third way is where a policy other than antitrust law ends up that it becomes important and it affects antitrust enforcement. And so just to drill down on that just a little bit, war often changes how administrations think about antitrust enforcement. Right. Yeah. And when you're in war is what matters. Right. So we've seen all of those. And I think understanding how those political environments existed gives a much richer understanding of the history of antitrust enforcement.
And Michael, what I like about your framing is that I think oftentimes people in the abstract think, well, laws are created through this very deliberative process, and because everyone believes that it's right for the country. And you and I were colleagues on the Hill. We understand that there are oftentimes political factors in the background that result in how laws are created or laws are enforced. So I think this framing is going to be useful for our conversation.
Well, thank you, and feel free to compliment any of my other answers as we go on.
Well, keeping with that idea of salience, what would you say about the initial birth of political antitrust?
So, right, antitrust started as a political movement before it was a policy movement, and it came out of the populism of the late 19th century from the Midwest. States like Iowa was actually the first state to pass an antitrust law, and it was very popular. There's some interesting stats. It passed unanimously in the House, the Sherman Act. Only one person in the Senate voted against it, Senator Rufus Blodgett from New Jersey. Don't know if that had anything to do with Standard Oil being a New Jersey company, but who knows? And so you would have thought that passing that kind of bill with that kind of popular support, and it was, support coming from agriculture, farmers, the agriculture industry, people upset about big oil, people upset about the big railroads, that you would have had this explosion of antitrust law. And you really didn't get that. And the best evidence of that, and I have to give a shout out to Senator Klobuchar's antitrust book, because this is where I found it, which I think is, obviously I'm biased, but I think it's a really good book in that it really ties this social history, political history to antitrust enforcement. But when Senator Sherman dies in 1900, the New York Times obituary doesn't mention the Sherman Act. And I think today people would only know two things about Senator Sherman. One, his brother was a famous general, W.T. Sherman, and two, the Sherman Act. But in 1900, it had so not been used that, and enforcement had been so unsuccessful that the New York Times didn't even think it was a big deal.
Yeah, and from my understanding too of the presidential administrations that were during that time with Grover Cleveland's second administration, it seemed that he was either hesitant or unwilling to pursue antitrust in a fashion that maybe some individuals in Congress would. And so that's a really interesting point that you bring up about certain individuals being hesitant while others were really pursuing antitrust in a fashion where we can see it today. What would you say was the first presidential administration that really promoted this?
So it was, ironically, in some sense, it was Teddy Roosevelt, who came from a very wealthy family, and he was very actually well connected to Wall Street, but he had developed a real concern about consolidation, and he's the one who brought the Standard Oil case and really made antitrust relevant. It was central to, and the point was, for him as president, this was a central issue. And that's, I think, what allowed the government to be aggressive in ways that it would have been impossible without that kind of political leadership.
Yes, and to provide a little bit more historical context around that, obviously antitrust enforcement was becoming even more popular or necessary, even if it wasn't popular. What was different about Roosevelt's administration? Why was he trying to focus on that? Was there some sort of outcry, or was it his personal purpose?
Right. Sort of what you have is the populist movement of the 1870s, the 1880s. Then you have, it sort of subsides, as you rightfully point out. Grover Cleveland is interested in trying to have a good relationship with business. It's a very conscious decision by the Democratic Party, who had not won a presidential election since the Civil War. But beginning around the turn of the century, these concerns pop back up. And so and Teddy Roosevelt, it's important to his administration. It's important to his successor, Taft, and it becomes even more important. And by the election of 1912, right, the antitrust enforcement was like central to that election. The presidential candidates are going out and give hour-long speech on their visions. And you have three different visions, but all of them reflected a concern about undue concentration, anti-competitive activity, right? And in some sense, ironically, Roosevelt was the least aggressive because he had come to view that we can't get rid of monopolies. We have to regulate them and live with them. Way to the right of that, way to the left, or on the other side of that, Wilson was really represented. We need to clean up the economy. We need to break up the trusts. We need to stop monopolies. And that's what we're going to do. And Taft sort of falls in the middle. But you don't actually have anyone saying, "I'm concerned about I'm concerned about government overreach." Right? You got three different views, none of which suggest nobody was talking, "Hey, let's go back to McKinley and Cleveland. That's when we had it right."
It's amazing how hot it was at that moment. Because if you think about it, Michael, until very recently, like for 100, 125 years, to the extent that anyone outside of this bar could identify a prominent figure associated with antitrust, it was the trust buster, Teddy Roosevelt, and those beautiful Puck magazine cover images that remain sort of staples of antitrust iconography of like the octopus and Standard Oil, all from that era.
Right. And what you see from that, because it's political salience, Congress passes the Clayton Act and the FTC Act, creating the Federal Trade Commission. One of the major drivers of that legislation was the Supreme Court decision in Standard Oil. So think about that. The government won Standard Oil. The government won on remedy. They broke up Standard Oil, and Congress was so upset with the judiciary and the rule of reason as they saw it, the court articulating, that they were like, "Fine, we're going to pass a whole new law so that you guys can do what we want you to do, and we're going to create an administrative agency to circumvent the judiciary." But it wasn't because of a loss; it was because the win wasn't big enough.
Yes, and kind of still pushing on that antitrust saliency period. What would you say were the themes of antitrust during FDR's administration? And can you touch on Thurman Arnold as an influential figure in antitrust policy?
Yeah, so two things. I think here we do see between Wilson and FDR, we do see this third idea I was talking about. 1917, the United States enters the war. The way, there's a very close relationship between the government and industry. The government's managing the war board and working very closely. And the Wilson administration walks away from antitrust, and so it was, I think, the war as much as anything. Then, just quickly on the election of 1920 is very much a laissez-faire election, right? Even though it's 8 years from 1912, and Harding wins on a very broad principle that we're governing too much. And so antitrust enforcement falls off a cliff in the 20s. So that's where we are. FDR, it's very interesting because at the beginning of his term, he actually wasn't that interested in antitrust enforcement. The thinking of what we would call the first New Deal was, we need to work with industry to fix this problem. And the people who sort of saw competition as a problem sort of were ascendancy. And so we see, right, the NRA was actually an attempt by the government to limit competition. Like, competition is reducing profits, and that's bad for the country. That lasts until the infamous decision in United States versus Schechter, which is mostly known for killing the first New Deal. But it also had the impact of making the Roosevelt administration reevaluate, and the anti-monopolists in the administration, like Robert Jackson, Harold Ickes, were in ascendance, and their view was totally the opposite. It was like, market power is bad. Market power, monopolies limit growth, distribute wealth in the wrong places. We need to attack this. And Roosevelt sort of comes to that because arguably his plan A was shut down by the courts. And so when the Roosevelt administration commits, it commits 150%. And first, Robert Jackson is appointed as the Attorney General for Antitrust, Assistant Attorney General for Antitrust, and then Thurman Arnold, who really, is probably the most aggressive antitrust enforcement period of our lifetime. Of the history of antitrust. When he got to the antitrust, and here we can see how politics affects policy. When Thurman Arnold gets to the division had 13 people. By the time he leaves, there are 500 people a decade later. Thurman Arnold brought more antitrust cases than the last 50 years prior to him combined. That type of enforcement really is only works if you have the White House and the Attorney General supporting you, right? So that you can take the heat is coming. If there's heat, it's being affecting. They're the ones feeling the heat, not this, sort of second level political appointee.
Kind of shifting from that salient period, going into the Eisenhower to Nixon administrations, why did antitrust take a backseat politically? Would you say that's kind of a downhill slide from the progression that Thurman Arnold made? Or what sort of themes would you touch on in regard to those administrations?
Right. So one might have expected Eisenhower's administration on antitrust would look a lot like Harding. Eisenhower ran on limiting government overreach. We were just coming out of a war. But it really didn't. Antitrust was not central to what Eisenhower was interested in. And so the antitrust division actually was quite active. And the Eisenhower administration's antitrust enforcement was very aggressive on mergers, right? And so was it the same as Thurman Arnold? No. But was it active? Yes. And, the difference is we're not groundbreaking. It's not the same change you saw with Teddy Roosevelt, or the same change you saw or the reverse change with Eisenhower, or the Roosevelt shift in 1938. Actually, it became, like I said, it sort of continued within, along the same broad path that the FDR's administration had. And in fact, some people would say, I think the Eisenhower administration was probably more aggressive than the Truman administration.
And so at some point, did precedent drive over any sort of political push? And at what point do you believe that occurred? And if it did occur, how did precedent allow antitrust to even move forward at all? Or was it stagnant?
The way to think about that is law enforcement agencies enforce the law as they see it. And where there isn't an overarching policy about how to enforce, the precedents are going to drive how they enforce. I mean, and so I think if you look at during Eisenhower, Kennedy, Johnson, the precedent there was very pro-enforcement. And so that kind of builds on itself. And right, if the Supreme Court, say in Philadelphia National Bank, says mergers above 30% are presumptively anti-competitive, and then additional language suggests very hostile to any rebuttal, if you're a government enforcer, you are naturally going to say, well, this says we should be very aggressive in going after horizontal mergers. And so in the absence of any countervailing policy views, the precedent, which had in the 40s and 50s, was very pro-enforcement, sort of came to fruition in the 50s, the 60s, early 70s.
Getting to the Reagan and the Chicago school kind of era, from my understanding, the fear of Japanese dominance and the overall concern about U.S. global competitiveness made a huge difference in how antitrust was enforced under those subsequent administrations. So, what sort of historical backdrop would you put on antitrust during that period of time?
Right. So, I think would be tendency amongst antitrust lawyers, and I'm part of this. Well, we look at the academic literature, the cases, and we see the increasing dominance and acceptance of neoliberal positions that government, we should be more concerned about over enforcement than under enforcement. Mergers are likely to be efficient. Hands off is the best way. And that's certainly, that debate is occurring and it is important. But I think equally important was by the time Ronald Reagan comes into office, we've had serial recessions. We are worried about our international competitiveness. And in that world, it becomes the proposed solution was we need to unshackle business in all sorts of ways. We see this in the deregulatory movement, and like antitrust gets swept up into that. It's part of a broader view that we face an existential threat about America's economic dominance, and that is what drives a fundamental shift in how the antitrust laws are enforced. And again, which is not to say there was no antitrust enforcement. I mean, right, the AT&T case is resolved under Reagan and Bill Baxter, but the 1982, you get the merger guidelines really represent a dramatic shift in enforcement priority. And I think the ability to make that kind of change really had to do with that antitrust was part of a larger critique of what was wrong with America.
Michael, where do you think these conversations originate? I mean, is it man on the street or academics who are sitting around talking about we need to unshackle American business? How much of this do you feel is, sophisticated political campaigns by the businesses themselves to get out from under government enforcement?
If I knew that, I'd be making a lot more money as a political consultant. I mean, look, I think you always have academics and scholars questioning whatever the status quo is. That's part of the process, right? And it's only at certain moments that those critiques become salient and have impact. And it's hard to, certainly industry groups are trying to just convince people about whatever it is they think needs to happen. Whether it's hard to determine how much that is affecting it. I mean, it does seem in the late 70s, early 80s, that antitrust just got swept up into a very bigger issue about the loss of American manufacturing. At the same time we were ratcheting down antitrust, we were doing quotas on imports, so I think there was a real sense amongst Americans at that moment, or a lot of Americans, that something had gone dramatically wrong and they were looking for a dramatically different direction. And the Republican Party and Ronald Reagan offered that, and antitrust was part of that. I think probably at that point, I'm hesitant to say that like people actually were like, no, we have too much antitrust enforcement. It was just the Democrats what we've been doing with government is wrong. Let's bring somebody different in to change it.
So I like the word that you use to describe this period of unshackling big business in order to potentially save some sort of economic turmoil or downturn. Has this been repeated throughout history? Is this where presidents tend to go to? Is this sort of a solution for economic turmoil?
So it's often a solution, as it was in the Reagan administration, but even for Democrats, as we discussed earlier about FDR, but even if you look at other Democrats like Clinton and Obama, who were generally, and I think actually not just generally, but believed in firmer enforcement, they did see in certain industries that they were concerned that antitrust enforcement could raise risks in certain industry, and most notably for both of them, it was in healthcare. And this really ties into that last theme, right? So both of those presidents were really focused on trying to expand healthcare access. And so it was a source of conflict whenever the argument was raised that, well, if you try to we as providers can't cooperate because antitrust laws. And both of them struggled with that issue.
Yes. So moving on to the Clinton administration and kind of the themes that administration exudes, was antitrust a political priority at that time? If not, how did the Microsoft case and other influential cases from that time come about?
So I think the Clinton and Obama administration were still in a framework that was generally hostile to antitrust enforcement. They were trying to, I think they were both in their own ways pushing back on that, but they were sort of fighting a defensive battle. So yes, the Clinton administration successfully prosecuted the Microsoft case. They also, at the same time, the government was losing massive numbers of hospital mergers. And as I just said, for the Clinton administration, they saw a tension between, particularly on healthcare, that antitrust was going to undermine healthcare reform. In the Obama administration, I worked for Chairman John Leibowitz at the FTC. We did score a victory on patent settlements. The Department of Justice blocked 2 health insurance mergers. So I want to be clear here. I'm not saying that they weren't aggressive, but I'm saying they were operating in an environment where it was not politically primary agenda item for the administration. And so, for example, when I first got to the FTC, Chairman Bob Potofsky, who is if you know anything about him, he was very aggressive. He was up on the Hill constantly trying to defend the agency because doctors were mad at him and they wanted a exemption from the antitrust laws. Hospitals were mad at him and the FTC and wanted a rider that wouldn't allow the FTC to enforce the merger laws against hospitals. Right when Obama, the antitrust enforcers were looking at the big tech cases. If someone ever gets to look at the letters from Congress from that time period, they were overwhelmingly they were hostile to enforcement, right? And so if that's the world you're living in, being aggressive means something very different than when the president of the United States, as in Teddy Roosevelt, is telling the world we're gonna take on the big trusts, we're gonna break them up. Right. So I think that's sort of the understanding that environment. And that was the political world was not that those administrations were lenient on antitrust. It was that was not a priority for them. And that affects how you can enforce the laws.
And going into the Biden administration and beyond, what would you say characterizes today's current state of antitrust? Does it look promising? Does it look stagnant? What sort of key players are involved under the Biden administration and currently that are making a difference or maybe causing everything to just kind of hit a stopping point?
So I think the answer is we have to wait and see. Though on the one hand, antitrust mattered to the Biden administration more than any other administration probably in our lifetimes. And the result was you had very aggressive enforcement. The Biden administration supported significant increases in funding. It's funny how these issues kind of keep circling back around. He appointed very aggressive people to run the two agencies, and Jonathan Cantor and Lena Khan. The Justice Department, we brought 6 major monopolization cases. We now have a new administration, and I think we have to wait and see what happens. I mean, it's very clear that administration is critical of some of the things we did, particularly our view on the benefits of settlement. On the other hand, they have supported the cases in litigation, the complicated Section 2 cases. So I think the jury's out, and it's really, you can't tell whether a major shift has taken hold until after. It'll be in 10 years we can come back and see if we really had a shift in the framework of antitrust or just a contrary blip.
Well, this has been a really interesting discussion because I think there's a tendency to look at either cases in the abstract or just focus on a particular point in time and an administration and focusing on their priorities, or even at most just looking at what that particular president says at a given time. And I think how we've talked about it is just not something we've really done on our podcast, but to think about, well, what makes the pendulum shift towards more enforcement? What makes it shift back? And I think this has been a really interesting discussion, and it's a great idea, Anna. So thank you for that, Michael. And now,
thank you guys.
Yeah, well, and now it's time for the segment we call The Curious Hat.
And now it's time for The Curious Hat.
Okay, so as our listeners know, Michael, the way this works is that Anna and I are going to each take turns asking you a question drawn from our Curious Hat. Short answers, please, Michael. Anna, would you like to start?
Yes, I know you gave me a little bit of advice to maybe stray away from antitrust since we talked about it for forever, but I am curious if you could have dinner with any historical figure in antitrust, anyone that helped shape antitrust policy, who would it be?
Thurman Arnold. Not a very creative answer, but it's a true one.
I guessed it, and I'm happy that I had it right.
All right, next question, Michael. Where do you come out on cargo pants?
I hate them.
All right, Anna, he got that one incorrect, so he's 1-1. Your question.
So are you a breakfast person, or are you crazy?
In Europe, I'm a breakfast person. I usually just don't have time if I'm not on vacation.
Okay, and lastly, Michael, you, like I, grew up on the school lunchroom staple Funyuns, but in recent times, Funyuns has moved beyond their signature beloved onion-flavored rings to include Flamin' Hot Funyuns, Steakhouse Funyuns, and Sour Cream and Funyuns. A question for you, Michael, is when is increased output a bad thing, and how do we make Funyuns stop?
Well, I think increased output is a problem when it's just a form of monopolization. So what we need is better competition to Funyuns, and maybe there's an antitrust issue there. I don't really need that, by the way. I have no idea about competition for in the Funyun snack category.
Perhaps this should be the subject of a future episode, Anna.
Yeah, you heard it there. Well, Michael, thank you so much for this. I learned a lot from you. It was definitely difficult to keep up with your immense knowledge of the subject, but I have left better than I was before. So I appreciate you for that.
Well, thank you again for having me on. I really enjoyed it, and I hope others do as well.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.